Hi, Alan. I'm here to help you understand the legal aspect of your recent property purchase, Pennyview Cottage. Today, I'll explain how the law protects your ownership and what we need to consider about Tina, who's living in the cottage, and David, who claims he has the right to buy it. So, we will go over three main questions. Number one, how the Land Registration Act protects your ownership. Number two, whether Stina's lease could affect your rights as the new owner. And number three, whether David's option to buy the property has any impact on you. Before diving into the specific issues related to your ownership, it's important to understand the distinction between registered and unregistered interests in the land. Property rights in land are attached to the land and can exist as either estates or interests. In your case, the issue revolves around interests, which are rights held by others on your land without ownership. Interests can either be legal or equitable. To determine whether an interest is legal or equitable, we will look into the Law of Property Act 1925, specifically sections 1 sub 2 and 1 sub 3. Legal interests are recognized and enforceable by common law, while equitable interests are recognized by equity. Legal interests must meet certain criteria, including being created through a deed, that is, a formal document used to transfer ownerships or create obligations, and being registered at the land registry. If these components are not met, the interest is considered equitable and may or may not be enforceable in accordance with priority and other aspects. Since your ownership of the Peniview cottage is duly registered, you are well protected as the official owner. For equitable interests, you can refer to Section 1 Sub 3 of the Law of Property Act 1925. An important concept here and another category of interest is overriding interests. Under Section 29 Sub 2 Sub A Sub II of the Land Registration Act 2002, overriding interests are given priority even though they're not protected on the register. These interests, which includes rights of people in actual occupation of the property and short legal leases, are relevant to our discussion today. They can still bind purchasers under Schedule 3 of the Land Registration Act 2002, even if they're not recorded on the register. The existence of overriding interests creates what is often referred to as a crack in the mirror of the registration system, which is designed to reflect the true state of affairs in land dealings. Overriding interests limit the mirror principle of registration, meaning that even though a buyer may believe they have complete knowledge of the property rights, hidden third party rights could still affect their ownership. The Land Registration Act 2002 was introduced as a significant reform to the Land Registration Act 1925. The Land Registration Act 1925 created the framework for land ownership records, but as land registration became compulsory in 1990, it was seen as an increasingly inadequate for the modern property market. The Land Registration Act 2002 was developed by the Law Commission and the Land Registry to streamline land dealings, improve efficiency, and align property law with the digital age, including provisions for e-conveyancing. One of the key changes introduced by the Land Registration Act 2002 was to limit the scope of overriding interests in order to make the land register more accurate. While many rights must now be registered to be enforceable, the Act continues to protect certain important rights, such as those of individual in actual occupation of the property, who may not be aware of legal changes. In summary, while the Land Registration Act 2002 strengthens the role of the land register, it still protects vulnerable individuals who may have hidden or unregistered interests, providing a balance between property transparency and the protection of these individuals. Let's move on to Tina's lease and how it might impact your ownership of Peniview Cottage. Tina claims to have a lease with Charles, the previous owner, allowing her to remain at the property for another 5 years. According to Section 1 Sub 1 Sub B of the Law of Property Act 1925, a lease is considered a term of years absolute and can qualify as a legal interest depending on its duration and other conditions. Under the Land Registration Act 2002, leases of 7 years or less are generally not required to be registered. This is outlined in Sections 3, Section 4 Sub 1 Sub C, and Section 27 Sub 2 Sub B Sub I. However, Such unregistered leases may still qualify as overriding interests under Schedule 3, Paragraph 1 of the Act. This means that even if Tina's lease is a short term lease, not requiring registration, it could still bind you as the new owner. Section 54, Sub 2 of the Law Property Act 1925 specifies that leases exceeding 3 years must be in writing. Since Tina's lease is for 5 years, she must provide written documentation to substantiate her claim. Without this, her lease may only amount to a contractual agreement which does not create an interest in the land. There are also exceptions under the Land Registration Act 2002 regarding unregistered leases. For example, right to buy leases under Part 5 of the Housing Act 1985, or reversionary leases, which are leases that commence more than 3 months after they are granted, are treated differently. From the information available, Tina's lease does not seem to fall under these exceptions. Therefore, if she provides proper evidence, it could qualify as an overriding interest. The Act also protects the rights of individuals in actual occupation under Schedule 3, Paragraph 1. This means that even if her lease is not registered, her claim could still be enforceable if she has been visibly and evidently occupying the property. Let's consider case laws for context. In Williams and Glines Bank in Boland, the court emphasized the importance of actual occupation in determining overriding interests. A spouse unaware of a remortgage had an overriding interest due to her actual occupation. This illustrates how actual occupation can take precedence over formal legal rights in some cases, as interpreted by Lord Wilberforce. However, in Abbey National and Cannes 1990, the court clarified that occupation must be visible or apparent at the time of the transaction. The defendant in that case could not claim an overriding interest because her occupation was not evident when the mortgage was finalized. In Tina's case, since she has been in actual occupation for the past 2 years, her presence at the property is likely to have been visible or apparent, strengthening her claim to an overriding interest. This principle is further supported by Thomas and Clydesdale Bank plc 2010, which emphasized that actual occupation must be evident upon inspection. Similarly, in Choker and Choker 1984, personal belongings were sufficient to demonstrate occupation. Since Tina has been living in the cottage for the 2 years, her occupation would likely have been apparent during any inspection of the property. Even if you argue that you reasonably inspected the property before purchasing, as suggested by the Law Commission, such a defense might not be strong. Nicola Jackson's critique points out that the concept of a reasonable inspection lacks clear guidelines. That said, Tina's position also depends on the formalities of her lease. As City PBS and Miller 1952 highlighted, an agreement to grant a lease is not equivalent to an actual lease and cannot constitute an overriding interest. If Tina's lease was not properly created through a deed or lacks formal documentation, her claim would fail. To support her claim, Tina would need to, number one, provide a written lease agreement to meet the requirements of Section 54, Sub 2 of the Law of Property Act 1925. Number two, demonstrate regular rent payments with evidence such as bank statements or receipts. Number three, establish that her actual occupation of the property is visible and apparent. Finally, there's the matter of the seller's disclosure. Under Section 71 of the Land Registration Act 2002, the seller is required to disclose any overriding interest, such as Tina's lease, before selling the property. If Charles failed to inform you of Tina's lease or misled you, you could have grounds for a claim of misrepresentation. Additionally, if you had taken out title insurance, it might provide financial protection against overriding interests like Tina's lease. This would safeguard you in the event her lease is upheld as an overriding interest. Let's talk about David's claim of an option to purchase, which he says he obtained 3 years ago. However, there's no mention of this option in the land registry. This raises several legal issues about its validity and enforceability. I'll explain the legal principles surrounding options to purchase and how they relate to David's situation. An option to purchase is a contractual agreement that gives the holder, which in this case is David, the right but not the obligation to compel a landowner, which in this case is Charles, to sell the property at a specified price within an agreed period. This right is typically treated as an estate contract and must meet specific formalities under Section 2 of the Law of Property Miscellaneous Provisions Act 1989, or we can refer to it as LPMPA 1989. These formalities are as follows. The option must be in writing. It must be signed by both parties, which are David and Charles. It must contain all the agreed terms within the document or incorporate them by reference. If David cannot provide written evidence that the option was granted in compliance with these formalities, his claim will likely fail. A helpful case to illustrate this is Spiral and Gun Crown Properties Ltd 1991. In this case, the agreement granting the option was properly written and signed by both parties as required by Section 2 of the LPNPA 1989. Later, when the buyer exercised the option by sending the seller a written notice, the seller argued that the notice was not valid because it wasn't signed by both parties. However, the court ruled that the only agreement creating the option must follow the former rules, which is exercising the option is a unilateral act requiring only the buyer's signature. There are two types of options. There's call option and put option. Call option grants the rights to buy the property, while put option obligates the buyer to purchase if the seller decides to sell. In David's case, only a call option will create an interest in the land. For this to affect you, it must also be property recorded in the land registry. Now let's talk about how options are protected in registered land under the Land Registration Act 2002. For an option to count as a binding interest, the agreement must be in writing, signed, and include all the key terms as required by the LPMPA 1989. The option must be registered as a notice under Section 32 of the Land Registration Act 2002. If the option is not registered, it does not automatically bind new owners like yourself. From what you've told me, there's no record of David's options in the land registry. This is significant because if David's option isn't registered, the law views you as the rightful owner, free from his claim. If the option was not registered, David might only have a personal right against Charles, the previous owner. This right does not transfer to you unless it was properly recorded. To clarify, in Pritchard and Briggs 1980, an option to purchase was treated as an interest in land, but it only took priority when properly registered. Without registration, new owners were not affected. An option to purchase is also considered a conditional contract for the sale of land. The seller Charles is bound by the option, but the purchaser David is not until he chooses to exercise it. For example, in Griffith and Plenton, the court emphasized that an option becomes a binding sale contract only when exercised. Similarly, in Helby and Matthews, the court explained that an option grants the right to compel a sale but imposes no obligation on the buyer until it's exercised. What does this mean for you? Ask David to provide the signed written agreement by which the option was granted. Without such evidence, his claim is likely invalid. Ensure there's no registered notice of David's option. If it's not there, you're in a strong position. If David insists, consult a property lawyer to confirm the lack of registration means his claim does not affect your ownership. If David cannot substantiate his claim, you are well positioned to maintain your ownership. However, if credible evidence arises showing the option was validly created and enforceable, you might need to negotiate or explore alternative solutions. David's claim hinges on whether his option was properly registered or supported by written documentation. If it isn't recorded in the land registry, it does not bind you as the new owner. The system protects you because you purchased the property in good faith and followed all the legal steps. To wrap things up, for Tina's lease situation, under Section 28 of the Land Registration Act 2002, your registered ownership will generally take priority. You won't be bound by Tina's lease unless her interest qualifies as overriding under Section 29 of the Land of Registration Act 2002. If Tina's occupation is visible and she provides the necessary evidence, her lease might qualify as an overriding interest. Should that happen, it could impact your ability to fully enjoy the property. However, you may have options such as taking legal actions against the seller, relying on title insurance for protection, or negotiating monetary compensation with Tina. As for David's claim, it hinges on whether his option to purchase was properly registered or supported by written documentation. If it's not in the land registry, it does not bind you as the new owner. The system protects you because you bought the property in good faith and followed all the legal steps. So you don't need to worry too much here. The law is on your side. provided everything was done correctly during your purchase. If you have more questions or need help verifying anything, just let me know.